Hello, everybody. Good morning. I'm Richard Wee. We are live today on this special webinar about the environmental law and climate change. This is part of RWC community webinar, and this is our ongoing series to share information. To educate the community and to try and how should I say, improve knowledge on certain areas of law. Today's topic is, as I mentioned earlier, is about the environmental law and climate change. We have here today my partner and colleague, Darren Lai, who will be moderating this event. And we are very pleased to have Mr. Kiu Jiayao, who I would like to say that he's a good friend of mine. We've been serving the bar together for numerous years, and it's a pleasure to have you on our webinar today, Q. Thank you for joining us. Yeah, lovely background, by the way, Q. Very apt. Even Darren purposely sat behind a plant to give it a more environmental feel. Yeah. So we are live on Facebook now. Those who are watching us on Facebook, thank you so much. What I'll do is I'm going to pass this microphone back to Darren Supase. Those who are in this room, thank you for joining us today. Do keep your microphone on mute, please. We will be adjusting the security as Darren and Q speak. The question and answer will be left later, but the moderator will tell you how that will be done. And for those who are on Facebook, what I'll do, Darren, I'll keep track on and follow what's happening on Facebook. If there's any interesting question, I'll cut and paste and send it over here. Okay? All yours, Darren. All yours, Q. All the best. Thank you very much.
Hey, all right. Thanks, Richard. Thank you very much. Well, good morning to everyone, to all participants in this Zoom meeting, as well as to everyone who's tuned in on RWC Facebook Live. My name is Darren Lai. Good morning, everyone, again. So welcome to this RWC community webinar. Today's topic is essentially on environmental law and climate change. It is a very wide topic, to be honest. We won't really, if we really want to talk about it, it will go on and on and on for days. But we'll try to cram up as much as possible in this 1 hour that we have here, all right? And to help me to do this talking is none other than Mr. Kiu Jiayao, right? A good friend of ours. So Mr. Kiu is a lawyer. He runs his own firm, and then also is the deputy co-chair of the Bar Council Environmental and Climate Change Committee. So, well, welcome, Jiayao. Thanks again for participating in this. Can I hand the mic to you to just give a few words of introduction? You're muted at the moment. Can you unmute yourself or?
Hang on.
Okay, Richard will do that.
Yeah.
Technical glitches.
All right. Hey.
Okay.
So thanks for having me, Richard and Darren. Thank you very much. And I'm very pleased to see some names I recognize and many others that I don't. So yeah, looking forward to this conversation. Oh wait, now Darren seems to be muted.
Okay, all right. Thanks, Jiayao. Okay, so well, let's get straight into it. As we say, we have so much to discuss within this hour. First thing first, when we talk about environmental law, I think the first question that pops up really to everyone's mind is, what is environmental law? Yeah.
Okay, great. Yeah, I particularly like your the questions that you prepared. You're starting from the most basic, and then sort of we're going to accelerate as we go very quickly towards the other end, which is environmental laws in Malaysia, and are we in a position where we can cope with the issues and challenges of climate change? So I think it's really important to start with the question of what is environmental law, and that's necessary because I think we got to understand what legal framework we have in the management and the use of our natural resources and our relationship with our natural environment in the context of Malaysia, right? So to the question, what is environmental law? I would say that environmental law is the category of laws that explicitly concerns the natural environment. So explicitly, right? So you got other laws and they make no reference to the environment. And so environmental law in that sense is a branch of law, right? So there's a whole tree of laws and environmental law is but a branch. That's how the context of it is how it's developed. A branch of law that started around perhaps the 70s, yeah, picking up more importance towards later in the 90s and in the early 2000s. So from this emergent body of laws, the prevalent perspective, I think, should be appreciated. You know? The perspective tends to be that the environment is there. You know, it is a thing that is separate and distinct from us. And from time to time, the law would require us to address our minds to the environment. So that perspective, I think, should be appreciated. That's how it started off, right? So in thinking about environmental law, it is important to see how the prioritization of environmental protection has evolved over the years. Because like I said, when we achieved independence, well, the first thing you needed to build a legal system is to have a federal constitution, right? A constitution that would be the foundation rock of the laws that will come forth, because you got to have that to build the institutions, right? Like the parliaments, the executive, the judiciary, right? The separation. And then on that, you have the lawmaking body, and then you have the law interpreting body of the implementation arm of government. And then the laws come in, right? And so when I say, in thinking about environmental law, we have to see how the prioritization of environmental law has evolved in priority. So we think back to, you know, when the nation was first formed, peace and security would be a priority. Citizenship would be a priority, right? And then access to the provision of basic services like education, healthcare, right? Justice. These are the more priority, the things that necessarily were prioritized. And then on creating livelihoods, right? Allowing individuals to, in a capitalist economy, which is what we've chosen. We didn't go the path of a communist economy, socialism, or so. Then we created company law. We had laws relating to factories and machinery and trade, right? And we focused on creating a suitable environment for more and more intense economic activity, because that was the idea of economic activity creating wealth, creating profits, and then within a system that works, a trickle down of that wealth, right? From first the shareholders who would benefit from that activity, down to the supply chain, and down to the rest of the actors in the economy. Now, in that prioritization, as we intensify these human activities, I'll call it, you know, the activities, business activities that provided for all the goods and services of that we needed and that we wanted. We realize, of course, then that it is important to control the management of natural resources, right? How, because in the provision, in the production of the goods and services, we necessarily need inputs from the physical world, from the material world. And so mining, logging, extraction of petroleum, these things were all intensified in the decades as we pursue towards becoming a more competitive country against a global context, right? So there was that hurtling towards that developed status. And so the prioritization ebbed and waned, and of course it kept rising, right? Because as more of these activities were becoming a burden on the environment, then we can see that the prioritization of environmental law rising. But at that stage, it would still be in that box, in that definition, right? So the environmental law started to come into the picture after company law was made. For example, our Companies Act, the first one was 1965, right? And then so like Factories and Machineries Act 1967, and various other important pieces came before. So those were written already, and they don't refer to the environment. The federal constitution doesn't explicitly refer to the environment, right? So its focus is on the human and human activity, but not so much the human and the environment kind of relationship, regulating that. So now, as we progress, then we realize that, hey, we need more of these. And so it was an ad hoc development. The biggest piece of law relating to the environmental law would be our Environmental Quality Act 1974. That's for the first time when we had a piece of law that governed we have to protect the environment, and we want to throttle down pollution, right? So we started to see that, so that's on some pieces of law started to come out. So it is an ad hoc process, and in that sense, but today what we have is it's fragmented, because environmental laws within that box, they emerged according to need. Right, and it emerged according to realization of impacts of human activity. Right, so that's a kind of a self-consciousness in that sense. Now, today, this narrow view of the environment, the environment is no longer suitable. Right, I think the writing is on the wall. We are now in an age that is we refer to as the Anthropocene. Right, this is an era when human activity has a significant impact on the planet's climate and ecosystems. So it's the age of because the huge number of human population, right, and the intensity of our consumption of the resources. So it's the Anthropocene where we are literally affecting and influencing the behavior of the planet. So we are a force of nature in that sense, right? So we are like the Gulf Stream, and even bigger than that in that sense. We are affecting it, right? So, which means then we really that means we have to take responsibility for how we manage our patterns of production and consumption, right? So because that's affecting the patterns of our climate, that's the reality of what the data is showing us now, and the reality of the Anthropocene. So the significant impacts that we're seeing is, besides the climate crisis, is the microplastic problem that we are having, right? Because of historical way in which we've gone about packaging and just using plastic so intensively. Now the reality is microfibers of plastic are found in most of the tap water in most countries, right? And they are small enough to enter the human body. And the World Health Organization has called for urgent study into the impacts of these microplastics, right? So that's another emerging crisis that we're having, among many others. So if before we were operating on a mindset, a paradigm, which is let's build and exploit first, and then we will restore or rehabilitate later. That paradigm has to be replaced immediately, right? Because that's an overdraft, and now we're paying for the overdraft because we have taken too much, right? We are realizing it now, and now we and our future generations are called upon to make good on our past indulgence, right? So and this has a lot of rights-based issues involved because it's already a burden, a negative inheritance that we're actually passing on. So now the label environmental law, right, is starting to lose its definability in that sense. It should, right? It should lose its neat delineation. It shouldn't be thought of as a branch of law because it is no longer practical to think about that. Plus, the paradigm shift that we need to have requires that it becomes embedded into the meta of our whole legal framework. That's necessary. So, for example, like Bursa Malaysia, in its listing requirements, making it mandatory for listed companies to publish sustainability reports, for example. Does that make those parts of the listing requirements environmental law? Yes. Right? So this is what I mean. So we really need to think outside of that environmental law label. It's a transition, right? So, but really, what it shows is that the narrow definition of development is bad. What we need to switch to is sustainable development. So yeah, that's my long answer to what is environmental law.
Thank you. Very insightful indeed. And I particularly like your analysis that priority makes law in a way, right? I think well, that's how law is generally developed from time memorial. In fact, I think if we look at how, taking a cue from your example of how plastics have been used, especially during MCO, that's just passed. I'm sure there are a huge amount of plastics, because of the takeaways and the deliveries and whatnot being used. But essentially, that may also mean that necessity also dictates the law, right?
So true.
Yeah. So, well, it's essentially what we live in, how we live in it that defines, right? And,
yes.
and I totally agree with your views that that environmental law has now developed, from protecting the tree or protecting a piece of land to something so much more complex, right? Well, great, thanks, Jiao. Well, we did mention about the EQA earlier. What are the on how it protects? It's an Environmental Quality Act. It speaks for itself, right? It protects the environmental quality. Are there any other laws in Malaysia that aims to protect the environment?
So in terms of the laws that protect our environment, the usual suspects, the narrow perspective, let's take the traditional narrow perspective would be, we have the Environmental Quality Act, right, 1974. We have the National Forestry Act, 1984. We have got the Wildlife Conservation Act, 2010. So these are the laws when we think about protecting the environment. We think about forests. We think about the charismatic animals. We think about the tigers, right? We think about our tapirs, right? We think about our elephants. Well, we've got no more rhinoceroses anymore. We've lost them, unfortunately. And so we think about our orangutan, our proboscis monkeys. So those are the things we think about. So and so we've got some laws in relation to protection of wildlife, in relation to sustainable exploitation of our forest assets, right? But I think the question of what are the laws what are the laws available to protect our environment? There's also a broader set of laws that actually are available and that are actually very important in the protection of laws, and they are being used. And to answer the question, I think it's useful for us to think from what are we protecting the environment from, right? So when you say, right, what are the laws that protect the environment? So let's just step back. What are we protecting the environment from? And the answer would be from human activity, right? If we frame it, right? So from human activity, because we're not protecting it from, meteors and Martian attacks, all right, or kidnapping of our elephants by aliens. Yeah. We are talking about protecting the environment from human activity. I think that's that's the framing to my mind. And so from there, it is useful to think about how we structure our society, because human activity exists within society, right? And so in society, we have three sectors, right? We have the public sector, and then we have the private sector, and then we have the third sector. The third sector being the non-governmental organizations, civil society groups, members of the public. So three sectors. It's important, I think it's useful to see it as in terms of these sectors, because the laws that apply in each sector are different, and the dynamics of the actors are also different. And you would, if you think the third sector, for example, when I say members of the public, 9 to 5 Mondays to Fridays, they could be working in the public sector, they could be working in the private sector, but then in their personal kind of civic space, they are members of society as citizens, and that's a third sector. So in that sense, we have these three sectors.
Yep.
So let's look at what the laws that protect our environment in the public sector. Let's start from there. In the public sector, which is the government side, right? So the Ministry of Environment and Water comes to mind, right? So that's the ministry in charge of the environment. And so they have various departments under the ministry, right? The Department of Environment, the Department of Irrigation and Drainage, various other bodies, wildlife, forestry.
Forestry, correct.
Yes, and so within them, they are in charge of. So it's not just the Ministry of Environment, but there are other related ministries as well that have to do with the land, that have to do with energy and technology, for instance, and trade. Now, under these relevant ministries, they will be in charge of specific pieces of legislation, the fragmented pieces of legislation I talk about. So under the Ministry of Environment and Water, we have the EQA is under it, right? That's the main backbone that protects our environment. So so they administer these laws, meaning to say they enforce the laws, right? So if there are licensing involved under this, then they are the ones that issue the license for the relevant human activity that is sought to be conducted. So they would then issue licenses that comes with conditions, that come with, together with it, that comes with monitoring and reporting and things like that. And then to then investigate when there are complaints of non-compliance, and then prosecution. That means investigating and then referring for prosecution, and then another body comes in, which is the Attorney General's chambers, will then decide on whether to prosecute, and if it does, it then takes it on into our criminal justice system, which is into our courts, using specifically the criminal justice system to go after, right, to exact these legal punishments against the so-called perpetrators, the ones who have flouted the written law, right? So that's that in the public sector. But there's another important piece of call it law relating to this in this public sector, which is judicial review. Now here the dynamics are switched when I say this. So then you're thinking about, say, the recent case of well, you can think of the Bukit Kiara case, where they wanted to develop, a developer wanted to develop parts of that forest for the development, and that was challenged in court through a judicial review. So this is where approval has been given for a certain project to which civil society do not agree with, and so they have an option to challenge executive decision in court. So executive decision means decisions that have been made by, in the three separate arms of government. You have parliament, you have executive, which is the prime minister and his cabinet, and then you have the third arm, the judiciary. So you're challenging executive decision, i.e. in this case, in this example, the approval for that development in this area to do this specific human activity. That can, if you meet the requirements of judicial review, to then bring an application to review the decision of the executive in front of the courts, to invite the courts to say, can you please review this decision because we're challenging it as a bad decision, a poor decision, right? And then you have to argue the merits. Why is it a poor decision? And in this case, what we will hear usually will be that it's essentially a struggle between economic development and preservation of usually the last tracts of our green lung, a gazetted forest. So like another example that was very well reported would be the Selangor government, the Selangor government's decision to de-gazette.
Correct.
Right, the correct word is excise, to the excision of a gazetted forest reserve in the North Kuala Langat forest reserve for mixed development, right? And in defending their, when they were engaging with the public, in defending the government, in defending their decision to de-gazette that land, they said that it's a wasteland anyway, it's prone to fires, so we might as well, develop the whole thing, right? And in the different lenses, when different interests are considered, that sounds very absurd, right? And so on what is important then is that in that struggle, then we hear and we see reports about its biodiversity. We are reminded that orang asli communities live on parts of it, and how efforts to rehabilitate that area have been very positive, yielding positive results. And so we see these different perspectives in that struggle, ensuing struggle against that decision. And what was good was, of course, in that case, that wasn't a judicial review case because they were at the cusp of filing that, I think.
Yeah.
But because of the coherence and the mounting criticism from civil society, many different organizations, the state government realized that they had to reconsider. And so that was but a body of laws in protecting in the public sector, protecting the environment in the public sector, judicial review is an important aspect, right? Mm-hmm. So judicial review relates to proportionality of a decision, whether it's right things have been considered, the process have been, due process have been. But very importantly is judicial review has its limits because most often the courts would say the executive is elected by the people. And so as long as the executive complied with the due process, the inherent merit decision is really for the executive, which is democratically elected, to decide. Is because the judges are self-aware that they are not democratically elected. On the other hand, now that's on the public sector. Onto the other sector where human activity happens, which is the private sector. So ours is, like I mentioned, an economy founded upon capitalism, and so the actors are the companies in this case, in this sector, and in our legal system, where it's democratic and it's perhaps reflected in its capitalistic economy, is then entrepreneurs, business leaders are free to apply your resources, right? Your capital, your resources, your assets, however you see fit, to do anything to generate wealth and profits, specifically for your shareholders, for their shareholders, as long as it is not illegal, right? So that's the paradigm here. As long as it's not illegal, not illegal under the Environmental Quality Act, not illegal under any other laws, specific laws, then go ahead. Because the idea would be that with these less factors, less restrictions, open up possibilities for innovation, for entrepreneurship, for finding ways, squeezing out, eking out ways to create value. That's the concept, right? So in this paradigm, we really count on the Environmental Quality Act to control the environmental impact of businesses, right? But let's be reminded again that the Environmental Quality Act is based on a very, very dated foundation. And so the degree of control is limited. Yeah, only certain types of activities are regulated. Only certain types of emissions, effluents, waste are controlled, right? And so, but there are many others that are not within the schedules, that are not within.
As we develop more and more, right?
That's right, and so it's not able to catch up, and it will always be on the back foot to catch up with the innovation and that diversity in the business world in terms of the kinds of activity that people are engaging in.
Correct.
Right? And so the Department of Environment then has to constantly play catch up to a vastly, exponentially growing complexity in the private sector. And so, by design, we're designed to always lose. And that means we always have pollution happening, and then we'll respond to it. And then we'll try to figure it out. And then we'll try to find some culprits. But that is the old paradigm. Yeah. That really is the old paradigm. That's right. So because the EQA, for example, only can control a few things, and that's specifically on air, water, inland water, right? Inland water, soil, and to some degree, noise, vibration. So, but what about the compounding effects of other things? So sometimes, so like, for example, look at haze pollution, this toxic haze pollution. Haze doesn't come straight out the chimney stacks of factories, it doesn't. However, it is like things like nitrous oxide that comes out, or sulfur dioxide that comes out. Then these things in the air, over time, they interact with other particles in our atmosphere, and they become haze particles. They become these particulate matters, which then, so it grows and it evolves into a haze problem. So you need some conditions, but the thing is, because we are creating a situation that can lead to that. So that kind of, that's just one example. And that kind of causation, that kind of consequence is really, really hard to actually monitor and control. And so that's really challenging in that sense. So the paradigm, the kind of framework that we have under the EQA is essentially a catch me if you can, and then you have to prove to a beyond reasonable doubt within the criminal justice system. So you can imagine then how effective is that towards moving the needle on being cautious about impacts on the environment. All right. So because against that backdrop, businesses would be, hey, look, it's the government's business to tell me what I cannot do. And then it's for them to catch me when I do the things that I'm not supposed to do.
Yeah.
So there's a wide margin, meaning to say then we get a sense that the responsibility is not on me because I don't think this causes those kinds of prohibited pollution. So I'm good to go, right? And then I generate wealth, I pay my taxes, I create trickle down, and the government should use that to sort out whatever problems that come out. Like, it's too complicated. I can't be responsible for those things, right? So that's the traditional paradigm. Now, against that, so I said, I come back to the private sector as a place to look at what are the laws that help to protect the environment. We have the traditional laws, I still talk about the EQA, but there's another piece of component here that helps to protect the environment, which is the thought of negligence.
Yep.
Right? So when actors in the private sector, in this case businesses, when they cause pollution, what I've talked about just a moment ago is about the government prosecuting them for infringements of the EQA, for example, for pollution.
Right.
Now, if they pollute, for sure, they are going to harm some other people, their neighbors, people around them, people who have to live with around the periphery of their operations. And these people who are adversely affected are protected, under our regime of laws to remedy, right? Because they suffer the harm. So, for example, if you're a flower orchard next to a neighbor who decided to develop their land in a way that causes water to run off their land into your orchid farm and destroy your products, your orchids, your nursery, then you can sue them for the tort of negligence and Rylance and Fletcher, right? So we have the nuisance, Rylance and Fletcher, the escape of a dangerous thing accumulated on your land to my land.
Correct.
So these are civil claims, causes of action that those who have been affected can go to court to enforce their rights. Now, so that's very narrow, because it's for landowners, it's for people who have suffered direct harm, yes. Right? It's very hard to preemptively ask for an injunction before harm has happened. Historically, from the extremely underdeveloped body of laws in Malaysia. But so you have to have suffered actual harm, you have to have suffered damages, and you have to, in some of the cases like Rylance and Fletcher, like in nuisance, you have to be property owner. And it's usually harm to property seems to be easier to make a claim. Now, still, these are tools that are available for accountability, right? These are tools to tell the story of, hey, you're doing your business activity, it's not illegal, well, because the government hasn't caught up, it hasn't come around to prosecute you. So I can't say that, me as your neighbor, I can't say it's illegal, right? But I can say that your behavior, your operations have caused me, have affected me adversely, caused me damage. And so I can then build a case about your irresponsibility.
Yep.
Towards accountability and towards nudging the needle on business responsibility. So that's one avenue as well for the protection of environmental law, right? Yep. So quick summary is that you have the laws that overtly protect the environment, and in this case, largely the government is supposed to be at the controls, operating these laws and implementing them, enforcing them. And the other side, you have the enabling laws like judicial review that allows civil society groups, those who are affected by poor decision-making or bad decision-making, to go to court to ask the court to review a decision by the executive. The other one is the torts kind of claim of Rylance and Fletcher's, which is through a civil claim. So that's using the civil justice system, the civil courts, to directly engage. So that's between those who are affected, or sometimes civil society and the businesses that are doing these operations in a harmful way. So there are these two things. So just connect. Yeah, go on, Darren.
Sorry. Essentially, well, basing it on, if we talk about judicial reviews or even private launched suits, negligence, for example, the courts do play a very large part in this, don't they? The judiciary.
They do. They have, I would say, they have a potentially large role to play. But the reality is, very, very few cases actually get to courts. And it's not because infringements of rights are not happening. It's because the pathways, the access to justice, pathways to court are extremely challenging. Two main reasons, I just say very quickly. Access to information is very hard. So it's very hard to get information to know quite clearly with a reasonable clarity, how did the harm happen to you, right? So you got to know, like, oh, where does this water that come from? Oh, it came from them. I suspect it came from them. But how do you prove it? So you need to have access. So your local council should have open in data, right? That allows you to understand, oh, they were doing their project, and that so if we have more access to info, we can see, oh, they were doing this project, they were supposed to do it this way, but they did it this way. If you have access to some of the approvals to the plans, for example, then you can tell, then you can start to articulate, right? Then your tongue becomes sharper in that sense, in articulating the connection between cause and consequence. So access to information is a severe pain point, right? Because we don't have that culture yet among the government agencies. Now, second one is on the rules of court. The rules of court are a thing that we have to facilitate disputes in court. So in Malaysia, we have rules of court 2012, right? It's been reformed in 2012. Now, the rules of court, if we take a step back again and we analyze, they are therefore facilitating disputes concerning property, concerning landowners, concerning commercial disputes, concerning things that want to ease of doing business, right? So it provides certainty for breach of contract, for shareholder disputes, for things like that, for a preemptive action when there is, say, infringement of intellectual property. So those, they work, right? We have clear rules around evidence, clear rules around injunctive relief that you can get, how you adduce your things, who are the parties. But environmental proceedings have a very different nature. No contract is involved. Yes. I'm related to you not because I consented to tango with you, but because I didn't choose you. You happen to be a neighbor. I'm in your vicinity, right? So I'm a unintended creditor in that sense, right? And so the rules of court then do not facilitate this. And so when the evidence come in, they don't fit. They're like square pegs in round holes. They're not going to fit in. And the problem is then they are then seen as bad evidence. But hey, it's not the evidence that's bad. It is the system, the rule that allows the access to court. That is the problem. So in many countries, we've got rules of court relating to environmental proceedings, but Malaysia, we are really backward. We haven't developed this yet. So this is a gap. So these two gaps are a big problem. Yeah.
Oh, that's interesting, which will lead us to a little bit of a discussion of overseas cases that happened recently, right? But essentially, this we have spoke a lot about environmental laws and whatnot. So one more, how to say, hashtag trending or even very important things that we need to talk about here is about climate change, right? I mean, that's essentially an environmental issue. Judging from the recent mega floods that happened late last year, I would say those are actually related, to climate change. So how does Malaysia have, in terms of the law, come in terms with climate change? Have we done anything in that respect?
So we don't have a climate change act yet. Yeah, we've got no legislation on climate change. What we do have is we have I would say an outdated national, there's a national policy on climate change from 2009. But that's a long time ago, because since then we have signed the Paris Agreement in 2015 with specific commitments, voluntary commitments, but still there are things that we agreed to do. And more recently in the Conference of Parties 26, COP26 in Glasgow, Malaysia has also agreed to the Glasgow Climate Pact. So that also kind of colors like where we should go from here, especially with the growing body of scientific evidence and the urgency around and what can happen from climate change. And also, like you mentioned, the floods that we've got, that we've seen, the shocking, severe weather patterns that we've got, and there's very, very severe consequences, right? Like people in Shah Alam dying from floods. It's unacceptable.
Yeah.
The thing is also, I must say, I think something that's unacceptable is we don't even know, is this caused, we can't even have a discussion about whether or not this was caused by climate change, because we don't have enough official data to say, is this because of excessive rainfall, more because of excessive rainfall, or is this because of bad urban planning, right? Poor water management, I think back to lack of information, lack of data, lack of that kind of proper analysis of our kind of situational analysis, right? Where we are in 2022 and what we need to do, that should guide, because that, you got to be, data-driven, evidence-driven, together with being rights-based. So a science-based and a rights-based approach would be the logical way to move forward, right? So right now we're not doing that, and we really lack leadership in this case.
Well, that essentially calls for perhaps another discussion of these days on Freedom of Information Act. Something which we are really lacking behind, unlike countries like Australia, where the FOI Act is readily available. Things are so easily checked upon, and I must agree that in every litigation, we must have facts, like how before we start anything, we sit in a room with the client for hours to grill them to every little small detail. This is exactly what it is, even in environmental litigation, right?
That's right.
Right, great. So, well, I wanted to ask you about who should be, responsible, who are the stakeholders and whatnot. But you have told us essentially the three branches of the society, from public to private to our third branch, the societal arm, right? So,
everyone is all of nation approach. We really need, because we are switching from the old school development into sustainable development. That needs everyone to be on board. But I think if you're asking who should lead, the executive must lead. Because why? If we're talking about climate change is a very complex problem, because it intertwines. Because it's not a problem of too much carbon or greenhouse gas in the atmosphere. It's not just that. It's not a scientific problem, right? So it is intertwined with how we generate our electricity, because the electricity enables our human activity. That's like everything, right? So how as a oil producing country, our economy is so heavily dependent on that, and it creates livelihoods down the whole supply chain in the oil and gas sector, right? So it is of strategic importance to us, but we need to decarbonize our economy. How are we going to do that? What is a just and fair, but also urgent transition plan? The government will have to lead. The courts cannot answer that question on their own, right? Because they need data as well, all right? They can look to the IPCC data by the United Nations scientists, but that's global data. What about our own context, right? We need to buat kerja. We got to do our own homework, do our own situational analysis, have our own struggles and discussions with what our aspirations are. How many people are we willing to accept to suffer the effects of climate change, including drowning, like what we just talked about? How much are we willing to accept? How much of our coast areas are we happy or comfortable with sacrificing, right? So I think the leadership has that ideally it has to come from the top. But leadership also can happen, really it has to happen because we also know that we are in a dysfunctional system right now, right? Because we have politicians who are openly self-serving. And so which means in practical terms, that dealing with climate change will only come after they've sorted out their own self-serving interests, right? So that's not going to be the best. So we really have to step up and be the resilient Malaysians to kind of like, what can we do in the freedom that we have in our own ability, right? How do we fill that vacuum?
Yes, and indeed, I'll put it in a very, very urgent need as well to tackle these issues, right? Yeah. Well, the Climate Change Act is in the pipelines, but where are we? Are you aware on that?
I'm not aware. So we've read some time ago that they've agreed on a legal framework of it. We haven't, so we're not at the stage where we even have a draft to look at. So there's nothing has been circulated or shared beyond some assurance that there's efforts in this direction. The climate change policy, the 2009 policy, was or is being reviewed. There were public consultation around views, but there's no leadership. That's my personal sense. I think civil servants are doing what they can, but then there's only so much they can do when you know at that top level. We're not prioritizing that,
unfortunately. Well, okay, right. So now, speaking of climate change, well, there is a growing trend, like I mentioned earlier, in all over the world. In Netherlands, to start with, there is the Urgenda Foundation case, and also in closer to home in Australia, there is the Sharma against the Minister of Environment, right? So these cases essentially, they kind of like open up the net of duty of care, you know, enable a larger group of people, and especially in cases like Sharma, where they allow a group of youths to actually start an action against the minister for consenting or approving a coal mining project, which will take about 20-30 years or so. Essentially, of course, this case was overturned on appeal, but the originating court actually opened up a very interesting view, you know. So Jael, any takeaways from these cases that you have read from?
I think it's encouraging, and I think all of us should pay attention to how the different actors in the three sectors are agitating for change and I say with air quotes, motivating the executive in this case, in both the cases you mentioned, motivating, prodding the executive to rise to the urgency of the climate challenge, right? i.e. saying that, hey, you're not doing enough, and then going to court to say they are not doing enough because of these things. So in the Urgenda case, what we see is the non-profit that focuses on climate change, Urgenda Foundation, taking the Netherlands government to court by saying that they took it from the ECHR, the European Convention on Human Rights basis, right? So they took a rights-based basis to say that the Dutch government have neglected their duty in not making executive decisions, let's just say, up to a standard that will ensure the protection of human rights according to the European Convention on Human Rights. So the courts there then assessed the existing knowledge and the science and the data around climate change and what is needed to avoid the 2-degree increase, which is we've all as a civilization agreed, you know, we should strive for, agreed to go for. And of course, we must remember that in that case, the Dutch government is a developed country, the next one country. So they have mandatory requirements in terms of cutting their emissions. And so the Dutch government looked at how the existing government's policies and their trajectory was failing that target, right? Yeah. And so the Dutch courts there, and they've appealed that, and the Dutch courts have agreed that the government had neglected its duty. So that was very powerful, and I think that's kind of set a precedent towards many other cases. And Sharma is one such case, and that's particularly useful to us as a common law jurisdiction, because the Dutch case is a civil law, that's a European law. But in the Sharma and the Minister for the Environment case, these teenagers, I think, going to court against the minister for saying that I think approval for the coal mine, the renewal of the approval of the coal mine, which commits them to the lifespan of coal mines are decades, of relying on energy from coal without adequate consideration for climate change. And the court agreed that there was a duty and that the Minister for the Environment had breached that duty. Of course, on appeal, the higher court overruled that finding, but it did not deny that climate change was, the data around climate change is not in dispute. And but it felt that the discussion around that duty and the standard and whether they failed it is in the political domain, right? It felt that. And so it was difficult for the courts to hold whether they have failed that duty. Now, what that means for Malaysia is, well, we also have the duty of care, right? And so there's a growing body of knowledge around this. And so, but we are a non-Annex 1 country under the United Nations Framework Convention on Climate Change, UNFCCC, which regulates climate change. We're a non-Annex 1 country in that sense. We don't have any, a mandatory emissions control. But, well, that's at the international level. We are not obligated to the matsales, for that. We have a right to development. But what about in the dynamic between us, Malaysian adults in charge today, and Malaysians' future generation tomorrow? They would turn around and say, yeah, that's all fine and good, but what? Did you do your best?
Yeah.
Like, you knew this, you could do this, and you didn't. We are saying you didn't do your best. I think that's a conversation that is in a cautious realm. And I think that's a relevant one that we should have, because that gives us focus, and urgency.
Yeah, it's probably also what did Greta Thunberg say? How dare you?
Oh yeah.
Yeah.
How dare you?
How dare
Yes.
you? Correct. Yep.
Yes. Because when you know better, you got to do better.
Correct.
Yeah.
Exactly.
Yeah.
Well, great. Thanks for the insight. So it's already 11:58. We're gonna.
We have a question here, Darren.
Yeah, sure.
Did you address it earlier?
I did not.
There's a question from Lisa. Does the EQA, it's sent to me directly. Does the EQA specify the need for the polluter to bear the cost of cleaning up the pollution?
Good question.
How about, I repeat, good question, Lisa. Does the EQA specify the need for the polluter to bear the cost of cleaning up the pollution? First question. Second one is, how about rehabilitation as well as future environmental monitoring costs?
Yeah.
Really good question.
Really good question. The EQA actually does have provisions for that enable the government to actually claim the cost of rehabilitation, charge it to the polluter. But it doesn't happen. All right. And I think it doesn't happen because of lack of resources. We just can't keep up. They can't even keep up with the punishing for the crimes itself, just prosecuting. We're seeing, anecdotally, we're seeing more and more compounding of offenses. That means they don't even go to court. They're compounded with a fine. And if they don't go to court, directors may not even know about it. Directors, as in the people who make decisions in the corporate organizations. So managers can actually pay a compound, and it may not appear in the official records as a conviction, because there's no trial, there's no prosecution. And certainly, if there is no translation of the cost of rehabilitation of the pollution, which will be sizable, like in the Sungai Kim Kim case, millions. If you bring those millions into those who are responsible or who collectively responsible, and you charge it to them, it hits where it is relevant to them, where it is visible to them, and that's the financial bottom line. Because like we talked about in the way we structure our economy, the private actors are only required to look at the financial bottom line, right? That's the traditional way, and we still do. So until you affect the financial bottom line, patterns of decision making are unlikely to change. Of course, there are other things that's going to be pushing and pulling against change in behavior, but this is where the actual cost. And when we don't claim the cost, when the government does not claim the cost of rehabilitation, one, there'll be no funds to rehabilitate, and probably we will not be rehabbing it. Two is the cost is then borne by the public, right? And that is what has been happening, and it's a severe thing. Now, if the court doesn't go after, if the DOE doesn't have resources to do it, what it can do today, while waiting for resources to go in, resources won't go in like the government is so poor. The government is using money in a different creative ways. Now, while waiting for that, don't stand in the way. The DOE should share information and allow for civil claims for those who are affected by environmental pollution to use that information, the data that we talk about, access to information to try and make their claims against those they think are accountable for the pollution. Civil justice system, right? So let those who are most motivated to bring the perpetrators to court, do it. Give them access to information, right? Show them, this is the data around the health of the river before, this is after, probably came from where, allow them, give them that, they can narrow it down on themselves, let them have their go in the court, right? So 2 avenues, both unexplored, very unfortunate.
Thank you, Kiu.
Yeah, do we have any more questions?
On my side, no more. I also don't see quite a number of clicks on Facebook, but no question. I think everybody digesting what's happening.
Yeah.
Cool.
So much. In fact, we haven't finished talking, I think. But due to the time constraint, we probably may need to have another part in the future. But we're surely going to ask Jaya to come back again. So, okay, all right. If there's no further questions, any last words from you, Jaya?
I think last words, oh God, last words is what a apt choice, isn't it? Last words. I think, yeah, I think it's when we know better, we gotta do better. It's really important for Malaysians. You know, Malaysians are very resilient, right? Against systemic dysfunction on the government side. But Malaysians, kita jaga kita, right? We're very resourceful, we're very agile, and we're deeply connected, and we care, right? So, and we build our own solutions, right? Where it should be in the public sector's realm. But Malaysians would rise to education, whatever it is, to fill the vacuum, forming their own groups, forming their own offer of information, and enabling each other and forming solutions. And I think this needs to happen, not just in the civil society groups, that's been happening more. Then we also need like business chambers, trade associations, because they, actors in the private sector realize that too. And they realize that it's crucial and it's part of being entrepreneurial, right? Because you know, every entrepreneur has to, you know, who doesn't have a good situational analysis is a really poor entrepreneur. And the good ones realize already, right? And they are embracing ESG. They are well on their pathways to sustainability. I feel that a very frequent frustration is the lack of leadership, and because then it creates regulatory risk to businesses, right? That makes it very difficult for businesses to say, let's commit on this direction, but then tomorrow the government goes that direction. Then, you know, it becomes very challenging. But having said that, I think counting on resilience of Malaysians, whichever sector they are in, including the public sector, because it's really important for especially for public sector Malaysians, wherever you are, whether you are in the DOE, whether you are in the local government approving projects, dealing with EIAs, whether you are an officer of the court, to appreciate that, hey, old school development is over and has to go out. Sustainable development, is a thing we must do. So then looking into what are the sustainable development goals that we have, and how does that translate into my own area of work, and then making an alignment between what I think, what I say, and what I do. That's making the most of our own freedom. Yeah.
Indeed. I totally agree with you on that, Jaya. And it's also interesting that you raised ESG. I think that warrants another discussion altogether. That's it expands the duties of directors in managing it. It's not only about dollars and cents anymore. It's also to take care as part of their social corporate responsibility, right? So, okay, with that, thank you, Jaya. Thank you for spending this hour with us, giving us very insightful takes into the environmental law, climate change as well. Like I mentioned, we still have so much to talk about. We will probably plan another session, right? And yeah, so and to all the other participants here and also on Facebook, thank you for tuning in. So this is another of our RWC community webinar. This time is on environmental and climate change. So thank you again for joining us. So see you all. Take care. Stay safe.
Been a pleasure. Thanks for having me. Bye.
Bye.
Thank you. Bye.